Hey folks, welcome to a Facebook page. I just posted this on my Heritage Wealth Planning Facebook Live page. I figure I post it here as well, just because I have more people on this Facebook Live than I do on my Heritage Wealth Planning one. When you see something that says Heritage Wealth Planning, it doesn't necessarily ring the same bell as it does from Josh Scanlon. So I want to share with you just real quick. I have this estate doc I'm looking at. These folks came in today. And I just want to share with you the importance of actually getting a real live estate planning attorney as opposed to A, not getting any estate planning done, or B, just getting like a legal Zoom or something like that. Again, just because you get an attorney in of itself who may do estates doesn't necessarily mean you're getting a real, what's going on in Alabama, doesn't really mean you're getting estate planning done. You just got to make sure that you're getting right guidance. And so these folks came in with a file this thick, and it's actually a privilege that folks would trust me enough to look through their estate documents. It's just it's wonderful. Actually, it makes you feel good, and you want to give them advice. Obviously, I'm not an attorney, and I would say this is something I see, and this might be something you want to talk about with your other estate planning attorney. Just to kind of go over this to make sure you're situated and squared away. So I just want to share with you this. And this is from a firm that says in their tagline, an estate planning firm. All right, they're not saying, we're ambulance chasers and we do estates on the side. That's what they do. They're an estate planning firm. And I cannot tell you how that is important. And so I'm going to read you this, their durable power of attorney. So this is from them. Obviously, I'm not sharing any client info. Alabama's present. Right on, Jim. Oh, man, Alabama, roll tide. Must be nice. The SEC always gets an automatic bid every time for NCAA football. If I had this other guy from Alabama on here, he'd be screaming bloody murder. Anyway, general durable power of attorney that was drawn up by a real live estate planning attorney. Warning to person executing this document. This is an important legal document. It creates a durable power of attorney. Before executing this document, you should know these important facts. 1, this document may provide the person you designate as your attorney, in fact, with broad powers to dispose, sell, convey, encumber your real and personal property. 2, as to your spouse as attorney, in fact, these powers come into existence immediately and will thereafter continue to exist for an indefinite period of time unless you limit their duration in this document. 3, as to all other attorneys, in fact, these powers will come into existence only upon your subsequently becoming disabled or incapacitated. See, Michigan's in the house. We got Alabama and Michigan. Hey, Big Ten versus SEC. I'm going for Michigan, that one. As well, these powers will come into existence only upon you are subsequently becoming disabled or incapacitated and will thereafter continue to exist for an indefinite period of time unless you limit their duration in this document. 4, you have the right to revoke or terminate this durable power of attorney at any time. Let me tell you what that says. This is fantastic. They're basically saying if you are going to grant your durable power of attorney to your spouse, she or he can act right now on your behalf without having to validate or prove incapacity. I cannot tell you how big that is. That means that you're saying to I'll just say your wife, for instance, wife, you have unlimited powers to do whatever you want on my financial behalf. Now, that doesn't mean the bank is going to accept those powers. At the end of the day, the bank's still going to accept it. You can bring down a piece of paper all day long and say, hey, I got this piece of paper. It says I'm the durable power of attorney. I'm the attorney in fact. I want to take a $50,000 withdrawal from my husband's account. The bank might say, we don't know if that's Photoshopped or not. We're not quite comfortable with that, but you have the rights as established right here in this document. And that's what we want. We want your spouse to be able to act on your behalf ASAP as quickly as possible. It doesn't, obviously, if you're not comfortable with your spouse doing that, you don't want this type of durable power of attorney. So remember, durable power of attorney. You're giving broad powers for somebody, the attorney in fact, to act on your behalf and your financial matters. What the limitations are, what you specify in the document. And if you're giving it to your spouse to act today, that's truly a durable general power of attorney. She can, or he can, act on your behalf even while you're sitting there and watching a football game. It doesn't matter. Now, what I love about this doc, though, it has a second caveat to all other attorneys, in fact. So Uncle Bob, these powers will come into existence only upon me, I'm the grantor of the attorney, the durable power of attorney, becoming disabled or incapacitated. So I flip over the page and say, how do we define disabled or incapacitated? And wow, lo and behold, section 1, for all purposes under this power of attorney, a person shall be deemed incapacitated if and so long as a court of competent jurisdiction has made a finding to that effect, or a guardian or conservator of the person or estate of any person duly appointed by a court of competent jurisdiction is serving. I'll explain that in just a second. 2, upon certification by 2 licensed physicians, a person is unable to take appropriate action with regard to his property and affairs. So what it's saying there is there's some hoops to jump in for for some non-spouse to act on my financial affairs. They can't just show up with some document and say, hey, little Billy is, he's not doing so well, so I need $50,000. They got to show from a court has got to agree, and on top of that, there's got to be 2 docs that sign off onto your incapacity. So that all this is saying is at the end of the day, most of us want our spouse unencumbered access to our financial affairs without having to jump through a bunch of hoops. We don't want some Joe scumbag out there, though, we thought was a good guy until he saw some money in front of us saying, oh, thanks. Now I'm going to go down to the friggin' bank and start stealing your money because I have the authority and there's nothing you can do because it's effective right now. We would like to avoid that if we can. And this allows that. Now, is this going to be appropriate for you? No idea. That's why you got to seek legal counsel, competent legal counsel. I don't know what your situation is. I am not an attorney. I know enough to read what the doc says, to explain it to my clients, and to tell them what they need to do next. I can't tell you, though, how many durable powers of attorney I've seen in some states, in particularly, which will go nameless here today, where they say, my spouse is my agent, in fact, but my spouse cannot act on my behalf until I get those 2 docs to sign off on my incompetence. I find that to be tragic, actually. And the reason I find that to be tragic, if we're driving down the road and I have a stroke and my spouse has got to have access to my accounts because I have the 401k, the IRA, I have individually owned accounts. That's my name and my name only on it. She might be the beneficiary, but she doesn't own the account. She has nothing to do with it. How does she have access to my money? She got to get 2 licensed docs to approve of that and then go to court. She needs the money ASAP. She doesn't need the money after that time period. Now, what's the likelihood the docs who don't know me are going to approve that? I don't know. I just know she needs the money. I write about that in my book. I had it here. I don't know what I did with it. But anyway, I write about that in my book in chapter 8 of Strategic Money Planning. And so that's critical. Secondly, you need a real live legal estate planning attorney too, especially if you have kids. If you have young children, who's going to be the conservator or the guardian, I should say? Who's going to be the guardian if something were to happen to you and or your spouse and you're dead? Again, so you're driving up I-81 through the Shenandoah Valley, some semi hits us, we're dead, my wife and I. The only people there's very few people that we trust too strong. Very few people that we want to act on our behalf to raise our children if we're no longer able. Let's just put it that way. Would the court see those people as we want them to be if we did not have legal documents to describe who those people are and who they should be? Maybe, maybe not. I highly suspect they would not, because the court's going to look in the bloodline. The court's going to say who is the capacity to handle these kids. And the court is going to decide who's going to be the guardian of my children based on the laws of the state. Well, if the laws of the state go counter to what I want to have happen, guess who loses? My children, because I'm dead. I can't contest it. I'm dead. I'm gone. The court's going to say, man, we got 8,000 kids running around through here. Half of them don't even know their dads. Their mom's freaking whatever. We got to get these kids in a foster home. We got to get these kids with, guardians at some point. We don't have the time, Josh, to be researching who you should be named as guardian, because you should have done that on your own. You have more than enough confidence to be able to figure that out on your own. And you need to do that. Can LegalZoom do that? Maybe. Should a real live estate planning attorney kind of help you and guide you through doing that? Absolutely. Does it cost money? Yep. How much would all that cost? $1,000, $1,500. Can't imagine it's much more if you're just getting durable powers attorney, your basic will, your durable powers attorney, your healthcare directive, your guardianship, all right, your letter of instruction, advanced medical directives, your living will. Those are basically the 5 docs that you need. Maybe $1,500, maybe $1,000 to get a real live attorney to draw that up for you. Worth its weight in gold. Do you need to do it every year? Nope. You don't need to do it every year. Do you need a living trust? Probably not necessarily for the vast majority of people out there. If you're doing living trust, it will cost you more for sure. But if you're just doing the 5 basic stuff, a will, durable power of attorney, healthcare directive, letter of instruction, living will, all those things, the healthcare directive and advanced medical are pretty much one and the same. All those 5 things right there, getting those drawn up by a real live attorney, well, I'm just telling you right now, it's worth its weight in gold and something you should do. All right. Hope this helps. I do like the Facebook thing a little bit. YouTube I like a little bit better because you can have a little bit of a screen share. I'm not sure why Facebook doesn't do that, but if you have questions, thoughts, concerns, just put them in the comments there below, and we'll see you next time on the page here. Thanks, guys. Bye-bye.